Welcome to Rev Up, a podcast series focusing on the people and issues driving the fast-paced automotive mobility industry. With a view on the future of mobility, the discussions on Rev Up will offer insights on the realistic and the futuristic in this evolving industry. I'm Amy Kottman, and you're listening to Baker Hosts. On today's episode of Rev Up, our host, Ashley Hess, a partner and co-leader of Baker Hostetler's automotive mobility industry team, is discussing a new national security law impacting connected vehicles and the automotive supply chain. Let's listen in to Rev Up, where the rubber meets the law.
Welcome to Rev Up, our podcast focusing on the automotive and mobility industry. My guest today is Melissa Menino, a partner at Baker Hostetler and co-leader of Baker Hostetler's international trade and national security team. The topic is connected vehicles and the automotive supply chain, and specifically, how a new law that became effective on March 17, 2025 has major implications for automakers, auto suppliers, and investors and dealmakers doing business in the automotive mobility industry. The new law addresses national security concerns posed by certain transactions involving information and communications technology and services. The law is a regulation out of the U.S. Department of Commerce's Bureau of Industry and Security that applies to connected vehicles and certain hardware and software utilized in connected vehicles. The law seeks to regulate Vehicle Connectivity System Hardware and Covered Software, or VCS, and Automated Driving Systems Software, or ADS, when there is a connection to certain foreign adversaries. The new law has very broad coverage, likely applying to every passenger vehicle sold in the United States on and after the 2030 model year. The law is complex and nuanced, comes with penalties for lack of compliance, and will force the industry to add steps in its compliance regime, increasing cost and the potential for delays. Let's get started with Rev Up, where the rubber meets the law. Melissa, welcome and thank you for being my guest. Why don't you introduce yourself to our listeners and tell us a little more about your background and your practice?
Ashley, thanks for inviting me. Excited to be here today and discuss this interesting topic. Said Baker Hostetler's international trade and national security practice is a full service practice addressing export controls, economic sanctions, foreign investment, trade remedies, import customs tariffs. My practice focuses on export controls, sanctions, foreign investment, and now the new regulations coming out of the Bureau of Industry and Security's Office of Information and Communications Technology and Services.
Yeah, and what an interesting time to be in your practice, especially with the impact that the new rules and laws are having on the automotive mobility industry. So today we're talking about connected vehicles and specifically this new rule that you mentioned from the Department of Commerce focused on connected vehicle technology. The new rule becomes effective March 17th, 2025. And the new rule impacts OEMs, suppliers, and multiple tiers of the supply chain, as well as investors in the automotive mobility industry. The new rule creates real compliance, operational, and risk management concerns, and therefore is something that needs to be on the radar of anyone in the automotive mobility industry. So, Melissa, as we start, I think it's important that we acclimate our listener and we talk about the background of this rule, how it came about, and then we'll get into the specifics of what's covered. So, maybe we start here at a very high level. We keep referring to this as a rule. So maybe let's just answer a question that may be floating through the minds of the listener of whether or not this rule is effectively a law and exactly what it applies to. So maybe just give a little background of where this originated from.
Yes, it is a rule and it's codified in the Code of Federal Regulations, specifically Volume 15, Part 791, and said it will be implemented and enforced by the Bureau of Industry and Security at the Department of Commerce. It's a rule that was implemented pursuant to the International Emergency Economic Powers Act to address the undue and unacceptable risk to U.S. national security and risk of U.S. person data relating to information that can be gathered and accessed by foreign adversaries.
Yeah. And so to pause there, so this originated with an executive order signed by then first term President Donald Trump in May of 2019 with the goal of examining how certain information and communications technology used in connected vehicles could be used by foreign adversaries to create certain danger for those in the United States. Is that a good way to summarize this?
It is. There's obviously the real risk of all this access to U.S. person data that could be obtained through, as we'll discuss, connected vehicles with vehicle connectivity systems and automated driving software, including surveillance concerns, as well as the ability to potentially hack into these vehicles and take control of them.
Okay. So this executive order charges the Secretary of Commerce with this rulemaking process, and the Bureau of Industry and Security is a bureau within the Department of Commerce that led the way on this rulemaking process. Is that right?
That is correct. And the Bureau of Industry and Security is best known for the Export Administration regulations, which is the dual use regulations for export controls. But this specific office now within BIS, the Office of Information and Communications Technology and Services, is that part of BIS that is responsible for this rule.
Okay. And I know as part of this, BIS undertook an advance notice of proposed rulemaking to solicit feedback from stakeholders and gather information that informed the way the BIS went about this rulemaking process and the proposed rule. And as part of that, BIS sought to understand how connected vehicles could be compromised, as well as input on the way that connected vehicles could be compromised and used by foreign actors.
Yes, BIS put out the notice of public rulemaking to solicit comments from the public, and then they consider those comments in implementing the final rule. And that final rule said was published in January of 2025 and said becomes effective on March 17th.
Yeah. And in this particular case, I know BIS received 57 comments during the advance notice of proposed rulemaking, and they attempted to craft certain definitions and the coverage of this new rule to address those concerns that came from that process from the industry. Okay, with that as background, Melissa, let's turn to what this rule is, and we'll start talking about how it impacts the industry. So, why don't you just describe in plain English here for us mere mortals, what is this new rule?
So the new rule contains three categories of prohibitions. Two relate to completed connected vehicles, and one relates to vehicle connectivity systems hardware, or VCS hardware. The two relating to completed connected vehicles are as follows. The first one is that the import or sale of completed connected vehicles that incorporate covered software, so either ADS or VCS software, that have a sufficient nexus to China or Russia, are prohibited from being knowingly imported or sold in the United States. This prohibition will start with model year 2027. The second prohibition on completed connected vehicles is broader, and it prohibits the sale of completed connected vehicles in the United States by any connected vehicle manufacturer that is owned, controlled, or subject to the jurisdiction of or is acting at the direction of the People's Republic of China or Russia. And these cannot be sold within the United States if they have automated driving software, ADS, or VCS software. And it does not matter who designed, developed, incorporated the ADS or VCS software. It's captured by who, by the connected vehicle manufacturer connections to foreign adversaries. The third prohibition relates to the import of VCS hardware. VCS importers are prohibited from knowingly importing into the United States VCS hardware that is designed, developed, manufactured, supplied by companies with sufficient nexus to the People's Republic of China or Russia. And this prohibition will begin with model year 2030 vehicles or January 1, 2029 or after if there's not associated to a model year vehicle.
Okay, so there's a lot to digest there. So let's start with some basics. So I think it's important for the listener to understand what is a connected vehicle. And this was part of the comment feedback that the BIS received from the industry around even the use of the term connected vehicle, but certainly what this term would apply to and just how broad it was. So let's start with just the definition of connected vehicle and how that came about. So, what is a connected vehicle?
So, a connected vehicle under the rule is a vehicle driven or drawn by mechanical power and manufactured that integrates onboard networked hardware with automotive software systems to communicate via a variety of methods to any other network or device. Essentially, according to BIS, that almost any model year 2027 vehicle and after will be a connected vehicle. The rule does not, however, capture all connected vehicles. It's only covering a subset of them. And it's those connected vehicles with a gross weight rating of less than 4,536 kilograms or 10,000 pounds. And for those vehicles that are primarily for use on public streets, roads, and highways.
And that's a really important nuance to understand. And it certainly limits the scope of what is a connected vehicle. What are they really carving out here?
So they're carving out commercial vehicles, some recreational vehicles if they weigh more than 10,000 pounds. But we do expect that a comparable rule or a similar rule will be released regarding the commercial vehicles.
Yeah, that's an important point and certainly something we're going to keep our eye on and cover in a later podcast. But it's important to understand that for right now, what they're focusing on are vehicles on the public streets and roads. So they're not focusing on golf carts. And then also with the weight limits that are part of this rule, they're not focusing on commercial long haul tractor trailers, and certain RVs, as you mentioned, would be too heavy. But I think one of the important aspects of this rule is the way that this definition is crafted. It really does cover almost any vehicle on the road because most vehicles that fit within the parameters of the definition are going to be connected vehicles.
Agreed. And that is certainly what the Department of Commerce has indicated as well.
And also, when they were going through the comment period, initially BIS identified 6 systems that it was considering identifying for coverage of this rule in connected vehicles. And those were the vehicle operating systems. Number 2 was telematic systems. 3 was advanced driver assistance systems. 4 was automated driving systems. 5 was satellite or cellular telecommunication systems, and 6 was battery management systems. And after receiving feedback from the industry, the rule really focused on vehicle connectivity systems, VCS, and automated driving systems, ADS, as you referenced before. So, Melissa, with that background for our listeners, let's delve into what is covered. What exactly is meant by vehicle connectivity systems?
So, vehicle connectivity systems are all the hardware components and software in a vehicle that allow it to communicate off board, communicate with surroundings, other vehicles, pedestrians. Things that usually identify a vehicle connectivity system are its ability to connect to Wi Fi, Bluetooth, smartphone integration. Now, there is a threshold here for what is a VCS under the rule, and that is hardware or software installed on a completed connected vehicle that directly enables the function of the transmission, receipt, conversion, or processing of radio frequency communications at a frequency of over 450 megahertz. They have specifically done some exceptions to what's covered here, and things such as LiDAR or hardware software that enables the transmission or receipt of automotive sensing or physical access to the vehicle are examples of things that are not included in the covered definition of VCS.
So, what the rule's meant to cover is VCS hardware and software that converts data into a format that is then transmitted outside the vehicle. And it's those types of communications that were determined to be high risk, and that's what's covered by VCS.
Yes.
Okay. So, that covers the vehicle connectivity systems. How does it cover automated driving systems?
Automated driving systems, for the purposes of the rule, is software that is capable of performing the entire dynamic driving task for the completed vehicle on a sustained basis. Essentially, it's a software that allows an autonomous vehicle to operate without a driver's input. For purposes of the rule, while it does not explicitly state it, it is the level 3 standard of autonomy. So, a driver, it is a mode in which all aspects of driving are handled for you, but the driver must be present at all times.
That's right. And just for some context here, for example, Tesla's full self-driving system is level 2 according to the SAE standards, and the SAE standards are the Society of Automotive Engineers standards that are generally referenced when discussing the level of autonomous driving. And from research that I did, it looks like Mercedes Benz is the first to offer level 3 system in the United States. And right now, there are very few of those vehicles actually on the road. There are other manufacturers who are developing and putting level 3 systems in other markets, but those are not yet in the United States. Melissa, does this rule cover all VCS and ADS?
It does not. So the focus of the rule, right, is on foreign adversaries or persons of concern. And the rule defines that as basically persons affiliated with or with certain connections with the People's Republic of China, so mainland China, Hong Kong, and Macau, as well as Russia.
So it covers certain geographies. And what's the reasoning behind this?
Again, that's where the US government believes is the risk to US national security, that these foreign adversaries would be the ones that the government has evidence that they are ones that are interested in obtaining US person data to use it for interests that would be contrary to the US national security and foreign policy interests and that could threaten US persons.
Yeah. And I think also it's important to understand that these are countries with governments that have the ability to have access to this type of data, in addition to just being foreign adversaries. So, does this law then only cover a company that's a company incorporated under the laws of China or incorporated under the laws of Russia?
No, it's very broad, and this is where I think the diligence and compliance burden will be extremely high on companies in the automotive supply chain. So, under the rule, it said it covers a person owned by, controlled by, or subject to the jurisdiction or acting at the direction of a foreign adversary. So, this could include any person, wherever located, who acts as an agent, representative, or employee, or is acting under the direction or control of a foreign adversary. And this means whether the foreign adversary can directly or indirectly supervise, direct, control, or finance that person. It could also be any person wherever located who is a citizen or resident of Russia or the PRC and is not a United States citizen or permanent resident. It can also include any person wherever located who is a citizen or resident of a foreign adversary or a country controlled by the PRC or Russia. And the only exclusion to that would be if that person is also a US citizen or permanent resident. It includes entities with a principal place of business in, headquartered in, or incorporated in the PRC or Russia.
But I believe the way that's written, it could also apply to a U.S. entity, so a company formed under the laws of one of the states of the United States, if that entity has ties to or is controlled by an entity or individuals in some of those jurisdictions.
Exactly. An entity wherever located that is owned or controlled by the PRC or Russia individual or entity would be captured, as would be any entity for which a PRC or a Russian national has the power, direct or indirect, to determine, direct, or decide important matters affecting an entity.
Okay, Melissa, we're talking about a rule with really broad coverage here. Do participants in this industry need to be concerned if they have an employee who is a citizen of one of these countries?
Under this rule, they don't. So companies that simply employ Chinese nationals or Russian nationals would not be a person of concern under this rule. They may need to be mindful of export control issues and technology transfers issues, but it would not be covered under this rule.
What about a supplier that has independent contractors or otherwise contracts with another company to do some software development for it? Should it be concerned about where the company is and alternatively where the employees of that service provider are?
Absolutely. And they will need to do the compliance under the rule to make sure that that independent contractor does not fall under the person of concern definition. And as we discussed, that is extremely broad. It can be a company, regardless of where it's located, that is under the control of a Chinese or Russian national.
So, Melissa, how does an automaker in the United States or a supplier that's supplying to one of the automakers, how do they confirm that they're going to be able to comply with this law? Because it seems to me that it takes a great deal of knowledge of the supply chain and the entities in the supply chain to be able to comply with this.
It's going to be a very heavy burden. And again, the prohibitions are on knowingly importing or knowingly selling. So there is that knowledge standard, but obviously one cannot stick their head in the sand or they're willfully blind. And if there's any red flags that come up in their diligence, they're going to need to address those. And for companies that want to, in addition, for connected vehicle manufacturers or VCS importers, they're going to have to submit a declaration of conformity to BIS to ensure that their transaction is not subject to the prohibitions in this rule. And that declaration of conformity is going to have a high burden because they're not only going to have to certify that their transactions not within the prohibitions of this rule, they're also going to have to certify that they've done the proper diligence. And they're going to have documentation that shows their diligence, including bills of material. And there's a 10-year record keeping requirement that goes with this. So why they don't need to necessarily submit documentation with the declaration of conformity, they are going to have a robust record of how they've completed their diligence with very specific details.
And the compliance documentation that you are referencing, this is part of the compliance rubric that's set forth in the new rule.
That's correct.
Yeah. And let's talk about timing here. You mentioned this earlier when companies are going to have to start complying with this law. What are the timing requirements?
So there is a little bit of a phase-in period here. So for the two prohibitions relating to the completed connected vehicles, that's going to begin with model year 2027 cars. For the importation of VCS hardware, that's going to begin with the model year 2030 vehicles. And if VCS is imported without connection without a specific model vehicle, it will be for 29. Interestingly, an important exclusion they have for this dealing with the connected vehicle software is that any of the covered software that was designed, manufactured, supplied prior to March 17, 2026 is outside the scope of this rule. So any vehicle that has the covered software for either ADS or VCS that was designed prior to March 17, 2026 will be outside the scope of the prohibitions of this rule.
Okay. And I'm assuming that was a concession to industry because of the lead time for manufacturing vehicles and determining what a vehicle is going to have on it in a certain model year. There had to be some lead time just for practical reasons.
Yes, correct.
So let's talk about compliance. You've mentioned some of the documentation and the rubric and the rule. How are those dealing with the supply chain, whether they're OEMs, whether they're auto parts suppliers, how are they going to comply with this and what's coming down the pipeline for them?
Yeah, hopefully they have already started vetting their supply chains. We've known about these concerns for a while. Obviously, the specific regulations here are more detailed, but they're going to have to go all the way down, right? They may even have to go into the ultimate beneficial ownership of certain, particularly with the VC, if you're dealing. So the compliance burden is going to be hard, and hopefully companies have already started doing the diligence because we've known about these concerns for a while. The focus will be mainly on BCS and ADS software. And anyone in the automotive supply chain is going to need to basically go back to the ultimate beneficial of owner of anyone in their supply chain for these parts of the connected vehicle to ensure that they're not going to be captured under the prohibitions due to the very broad definition of person of concern under the rule. And I think it's going to be very hard to get that information. It's not information that suppliers may necessarily have or want to provide.
Yeah, I think that's a really interesting point. And I've been in this industry for 25 plus years. And one of the things that I've noticed in the last several years are new entrants into the supply chain, especially on the software side. I think you're going to continue to see this. There's going to be innovation, and that new companies are going to be entering the supply chain. That's going to make this more burdensome, and it's going to make it an issue that suppliers and the OEMs are going to have to stay on top of, and they're going to be consistent with it to make sure that they comply. Another issue I wanted to bring to the attention of the listener is you mentioned this record keeping requirement of a 10-year requirement. That's burdensome. And there's turnover at suppliers, there's turnover at OEMs, and there's going to have to be a real compliance system in place to make sure that record keeping is done and that documentation is saved so that they can make sure they comply with this, especially if BIS or someone from the Department of Commerce comes by to do an audit on these issues.
Agreed. And I certainly expect that BIS will be conducting audits on these issues and potentially asking for supporting documentation when declarations of conformity are submitted.
So, Melissa, this is a rule with broad coverage. Does this mean that if an import fits within this prohibition, it's done? It absolutely can't move forward and can't come into the United States?
No, not necessarily, because there's two paths for authorization under the rule. There's general authorizations that BIS will publish on its website. And if you fall within the general authorization, that means you can proceed with the transaction even if it's covered by the prohibition. Now, importantly, a person that is owned, controlled, or otherwise falls within the definition of a person of concern is not eligible to take advantage of the general authorizations. But it can be used for other transactions, imports that would fall within a prohibition. In addition, if you want to proceed with a transaction that is not covered by a general authorization, you can go into BIS and apply for a specific authorization or a license to proceed with the transaction.
Yeah. So another issue I want to touch on is the automotive industry is seeing a great deal of development. We're going to see, especially in the ADS area, you're going to see a great deal of development as we go from level 1 and level 2 autonomous vehicles to level 3, 4, and 5 in coming years. For those who are doing transactions in the space, and I'm talking about mergers and acquisitions transactions or investment transactions, what are some of the diligence concerns that need to be at the forefront of thinking for people who are looking at doing deals in the space?
Yeah, so it's going to be similar to the compliance that needs to be done to ensure that you're not having a connected vehicle that would fall within the prohibitions of this rule or VCS hardware. And I think this is going to be a very interesting area because I think it's going to be fluid. We're going to see potentially other rules coming out. They're going to capture the commercial vehicles. In the President Trump's America First trade policy, there's actually a specific provision in here that he will look at this rule. And I believe that he could actually expand the scope of it. I don't think he would narrow the scope of it. So when you're doing that, yes, you need to be focused on what the rule is and the law is as of the date, but also be mindful of what could potentially be covered here in the future. And so I think you're going to do very thorough diligence to understand any and all connections, particularly to the PRC or to Russia in any parts of the business, obviously, in addition to just the VCS and the ADS, and have fulsome reps and warranties in the deal documents to address these concerns.
Yeah, and that's a really important point. It's on the diligence side and then on the documentation side, and query whether these are the types of issues that can just be covered in a broad manner with general compliance representations. So let's talk now about what happens if there's a violation of the rule. Are there penalties for violations?
There are penalties for violations, and it can be civil or criminal. And again, civil would be enforced by the Bureau of Industry and Security, and the penalties can be particularly significant. The penalties come from the International Emergency Economic Powers Act. So a civil penalty for one violation of the rule can be over $370,000 per violation.
Okay, yeah, those are pretty stiff.
Italy, it can be $1 million and or jail. But
Yeah, usually those criminal sanctions or penalties get people's attention pretty quickly. Okay, Melissa, this has been chock full of information. What else do we want to share with our listeners in terms of compliance and learning more about this new rule?
the Bureau of Industry and Security's Office of Information and Communications Technology and Services does have a great website, and they have a special page dedicated to connected vehicles. And so that is a great resource for anyone to take a look at. However, due to the complexity of the rule, its nuances, and what we think will be robust enforcement of it, we strongly recommend that companies have written policies and procedures to address this rule, have specific certifications that their suppliers will sign to show that the companies have done the proper diligence and that can make the declaration of conformities or the necessary information to apply for an authorization from OICTS.
Those are important points, and I agree, those are tremendous resources. We recommend those to the listeners. So, Melissa, let's talk about what else is going on in your practice. As I mentioned in the beginning, it's got to be an exciting time to be in the international trade area. It has to be an exciting time to be in Washington, D.C. right now. So, what else is hot in your area?
It is an interesting and exciting time to be an international trade and national security practitioner. I think going along with sort of the theme of this rule is we are seeing a lot more regulations being targeted at specific persons of concern. And this is something I think the U.S. had avoided for a long time, particularly now where we're seeing in either, again, lot of international trade transactions or M&A transactions, or helping companies that want to come in the U.S. to develop operations, that there is a myriad of laws now that are particularly focused, particularly on the PRC. And so we are helping companies globally with navigating these types of laws, whether they're buying land in the US, whether they want to make a greenfield investment in the US and start a facility up from zero, whether it's that they want to invest in US companies or US persons want to invest overseas. And so this web of laws now has created very interesting issues and complex issues.
Melissa Menino, thank you for being on Rev Up, where the rubber meets the law. It's been great having you.
Thank you for having me. It's great.
Thank you, Ashley and Melissa. If you have any questions for Ashley or Melissa, their contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.